All right, one other person has shown up. And I'm sorry, say your name again, sir?
Solomon Samudio.
I don't see your name on anything.
He's Zamudio.
Oh, I thought he said Solomon.
Yeah, that's his first name. He's third one down at 130.
Oh, okay. Sorry. All right, looks like I do have two Zamudios here and Mr. Navarre.
Good afternoon, Your Honor.
Good afternoon. Okay, we're scheduled for trial today. Come on forward, sir. Have a seat on that side, if you would, please.
Is that plaintiff right there?
Yes. Okay. Sorry, I thought I said that already. Okay, are we going to have a trial today, Mr. Navarre, or were you able to work things out?
I haven't had an opportunity to talk to the defendant herein, but I have talked with my client. It's her understanding that the issues as it relates to custody, support, and parenting time have been resolved with the order that entered after meeting with the friend of the court, and is the order which is the current order of the court.
So is that correct, sir? The temporary order for custody, parenting time, child support is acceptable to you?
Yes.
So we could make that part of a permanent judgment of divorce?
Yes.
Okay, what else is there, Mr. Navarre?
Your Honor, there is a debt that is outstanding that was incurred in my client's name for the benefit of the defendant herein. And that was an auto loan, which she took out in her name. And that he was supposed to make the payments. He was the one that had the vehicle. And there was a judgment that entered against my client by Marquez Auto Sales and Service. And that was decided in October of last year. And that was in the amount of $6,111.26 for non-payment of that installment loan. I think that there was an accident, the vehicle was totaled, and subsequent payments were not made. My client had to take a loan out in her name due to Solomon's status, and we would ask that at least he have a minimum responsibility of 50% of that outstanding debt, and that is out of Allen Superior Court, numeral 2, I believe in the state of Indiana, and it's docket number 02D02-1812-SC-018989. And again, that was decided on the 24th of October of last year. My client is the only one who's named as a party defendant to that. And that was a debt that was incurred for the benefit of the defendant.
So, sir, are you willing to be responsible for half of that debt?
Yes.
He's willing to do that, Mr. Navarre?
I believe that the personal property has been divided. Karen, are there any other issues that need to be addressed right now that the judge needs to know about?
No, not at the moment, no.
Okay. So that will cover everything, correct?
Yes.
Judge, if I may proceed, then I would like to have my client put on proofs to support the entry of a judgment of divorce.
Certainly. Ma'am, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You can put your hand down, state your full name, please.
Karen Suzanne Zamudio.
Go ahead, Mr. Navarre.
And Karen, how do you spell your last name?
Zamudio.
And Karen, you signed a complaint for divorce in this matter. And when you signed that complaint, were the allegations true? And do they remain true today?
Yes.
Are you currently pregnant?
No.
Has there been a breakdown in your marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Correct.
Are you seeking entry of an absolute judgment of divorce?
Yes.
And you and your husband Solomon have previously divided personal property, is that correct?
Yes.
And you and your husband own no real property or real estate on your own or together, is that correct?
Yes.
So there's no real estate that needs to be divided, just personal property, and you've already done that, is that correct?
Yes.
Is that division fair and equitable as far as you believe?
I believe so.
Okay. And you heard what the court was willing to do, or as it relates to this outstanding debt for the vehicle with the small claims judgment in Indiana, that you and Solomon are both going to be responsible for 50% of that, and that would go into the judgment of divorce. Is that acceptable to you?
Yes.
Thank you, Your Honor. I have no further questions of the witness, and I would move for entry of an absolute judgment of divorce. I will submit that as Your Honor directs, and I would indicate to the parties that they're not divorced today, that they won't be divorced until the paperwork is signed and approved and entered by the court. Solomon, if I send that paperwork to you or provide it to Karen, can you sign that paperwork if it reflects what the court has ordered today and what is currently in order through the temporary order through the friend of the court through the conciliation process?
Yes.
Okay, I think we kind of have the basis of a consent agreement on the record, but I'm just going to clarify to make sure there's no problem. So, Mr. Zamudio Morcacio, okay. You are in agreement that the provisions of the temporary order regarding custody, parenting time, and child support previously entered in this file become a part of your permanent judgment of divorce?
Yes, I just had the same question that I had before, that he was gonna speak to Karen about 5 months that the kids had spent at my mom's house. With her only seeing her, the kids 3 times. My other concern was that she left to go to UP the Friday after we had last court, and left the kids by themselves since 5 o'clock in the morning. I do have a police report that about that.
So I cannot address that specific issue today. All I can say is the terms of this temporary order will become part of the permanent judgment, and I expect you both to abide by it. You're willing to abide by it,
Yes,
and you want her to abide by it.
yes,
Okay. Does that address your concern?
yes.
Okay. Can you confirm to me that you are not seeking any spousal support?
No.
And you agree that it should be forever barred? You are not seeking any right on your own behalf in any policies or contracts of life insurance, endowments or annuities on the life of your wife? You're willing to extinguish those if they exist? You're not seeking any interest in any pension, retirement plan, retirement savings that your wife has? And you're willing that any of the such right that you might have in those things be extinguished by a judgment of divorce? You agree that you've already divided your personal property? You agree that you don't own any real estate?
Yes.
And you agree that you're going to be 50% responsible for the small claims judgment, or from the judgment that arose from this non-payment of a vehicle obligation? All right, typically that will include language that says if she has to pay any of your half, you're going to indemnify and hold her harmless for anything she has to pay over that 50% amount. You understand that?
Yep.
And you're okay with that provision?
Yes.
That will be mutual.
Your Honor, as it relates to that provision, I standardly incorporate language that indicates that if she's required to pay or he fails to pay, or vice versa, that the non-defaulting party would be entitled to spousal support, which would be non-dischargeable in bankruptcy. But other than that, my
But
client
spousal
would have
support-
a statutory right to that.
Spousal support in the net amount, or gross amount rather, of whatever either one has to incur because the other failed to abide by the obligations of the judgment?
That's correct, Your Honor. And given
Okay.
the change in law under the Tax Cut and Jobs Act, it's non-deductible and non-includable, so that's a non-issue as it relates to net or gross.
All right, so I want to make sure you understand that. The provision he's going to put in basically says if you or she fail to pay your half of that obligation, that the obligation will be converted essentially to an amount of spousal support equal to the amount that you didn't pay. And the reason for that is to make sure you can't discharge it in bankruptcy.
Right, no, I have full intention of paying
Okay,
what needs to be paid.
all right. I think we have a full agreement on the record that the court would be able to enforce. I expect if you get a form of judgment from Mr. Navarre that reflects everything we put on the record, just sign it and send it back to him. And as soon as I get that back, you will be divorced.
All right, thank you.
Your Honor,
Okay,
if
any
I
other
may-
questions?
If I may, Your Honor, inquire of my client as it relates to the further inquiry that you had of Mr. Zamudio Morcacho.
Certainly, go right ahead.
Karen, you heard what the judge asked Solomon, correct?
Yes.
And your answers would all be identical to his answers, is that correct?
Yes.
If you're willing to have these additional provisions put in, which are pretty much standard provisions that would be in a judgment of divorce, you're willing to live up to and abide by and follow those orders of the court that are going to be contained in the judgment of divorce. Is that correct?
Yes.
And I want to ask you that, you know that you have the right to go to trial today and that your husband has been defaulted, but that you feel that the agreement that you've reached, the parenting time and custody and support that is outlined in the temporary order is in the best interest of the kids and also is fair and equitable. And that's something that you are willing to accept, adopt, and follow. Is that correct?
Yes.
Did you understand that you could have done better if we actually had a trial? Do you understand that you may have come out better from a property standpoint or otherwise if we had a
No.
trial?
No.
Okay. You understand that you might have done worse if we had a trial?
No.
Okay. You have the option to go forward with the trial, but do you feel that this is fair and equitable and in the best interest of the children to settle the matter on the terms that have been put on the record today?
Yes.
And you satisfied with my assistance of you in this matter as your attorney?
Yes.
I have no further questions, Your Honor.
Thank you. I do find that there's been a breakdown in this marriage to the extent the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. I will sign that consent judgment of divorce upon presentment. We'll set a status conference in 28 days. As long as the judgment is in before that time, there will be no need to appear.
Judge, I have one more thing I'd like to state on the record today, if I may briefly. And that is that there was a period of time this past summer that the children were in the care of their grandparents. And that was because of concerns that my client has as a frontline hospital worker for Henry Ford Allegiance Health. She works in the COVID tech, Your Honor. And so initially she was concerned about transmission to the children. And so for purposes of safety, protection, during this COVID-19 pandemic, she felt that it furthered the children's best interest for them to primarily be with the grandparents for a significant amount of time over the past several months. And so that was the reason for that, but that is not the situation now. The children were residing for the summertime significantly with the grandparents in Morenci, Michigan. Mr. Zamudio Mortecho resides in the Marshall area. My client's here in Napoleon, where the children are in school. And so I wanted to put that on the record to indicate that that was a parental decision that was made to further the kids' best interest. With that, I will conclude and close the record.
Okay, thank you very much. That concludes our hearing. Have a good day, sir.
Thank you, Your Honor. Karen, I'll give you a call.
Thank you.
And you are Shimon Hayward?
Yes.
Come on forward. Peter, if you could put these in Dawn's box and tell them neither party showed for the trial today. Sure. Okay, your name is Shimon Hayward?
Yes.
Okay, your case is scheduled for trial today. I see from my note on the file that Mr. Hayward is in default and he is incarcerated, if I recall correctly, in another state. Which state is that?
Think Kentucky.
Kentucky. All right. When I have an incarcerated parent in Michigan, I make arrangements for their participation. When they're incarcerated out of state, I don't have any control over that. He is in default. He was served properly with the complaint and he failed to answer in a timely manner. And you have filed an application for default. He's taken no action to set aside that default. So I can proceed today based solely upon your testimony. So would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Put your hand down, state your full name for the record.
Shimon Antoinette Hayward.
So Ms. Hayward, you filed a complaint for divorce a little over 6 months ago, actually back in March. So that's accurate. Was everything in that complaint for divorce true at the time that you filed it?
Yes.
And is everything true today?
Yes.
You have one living minor child born or adopted during your marriage to Mr. Hayward,
Yes.
and that is Alan Hayward, born May 9th of 2015. Okay. According to the temporary order, it says that Mr. Hayward is at least at that time, was incarcerated in a federal correctional institution in Pennsylvania. But to your knowledge, he's actually been moved from that facility? Okay. How long has it been since Mr. Hayward has seen Alan?
Let's see, it's been well over a year since he got been in Pennsylvania, so yeah, it's been over a year.
And do you have any idea what his sentence is?
How long?
Yes.
According to BOP, it is May 2026. However, he assumes that he will be getting out by the beginning of the year.
Okay. There currently is a temporary order in place which gives you sole legal and physical custody of the child. Parenting time is at your discretion, and upon his release, he can file a motion to readdress parenting time. Currently, because he's incarcerated, he is unable to care for the child or to have parenting time with him. There's no other viable place for Alan to live other than with you. When I'm making a custody decision, the statute requires that I address the best interest factors. I'm going to run through those quickly just to make sure there's something on the record.
Okay.
Based on your testimony already, I can probably make these findings pretty easily. Let me find the list. This child has been living exclusively with you for at least the past year
Yes,
and has lived with you his entire life,
he has lived with me since he was 2.5.
since he was 2.5.
Yeah.
Okay. Clearly, for the last year or longer, he has not lived with his father at all.
No,
All right, it's clear that there is an established custodial environment with you.
yes,
The factors include love, affection, and other emotional ties existing between the parties involved in the child. Is it correct that you have a very strong emotional bond with this child?
yes.
How would you describe the child's bond with his father?
His bond with his father, he hasn't had really, other than the visits, he hasn't really had the chance to. His father's been in prison since he was 5 months.
Okay.
So,
Does he even recognize his father?
yes, I did do that, so as far as visitations.
The next factor is capacity and disposition of the parties to give the child love, affection, and guidance and continue his education. That's not an issue. And the raising of the child in his or her religion or creed. He has no capacity to do those things currently because he's incarcerated.
Yes,
Next factor, capacity and disposition to provide the child with food, clothing, medical care, other remedial care. Again, the father has no capacity to do that because he's incarcerated. Length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining it. Clearly, the child has been living with you. That is his home. There is no home environment with the father. Permanence as a family unit of the existing or proposed custodial home. Who resides in the home with you?
me and my 2 other children.
Okay, and how long has that family unit been a family unit?
Since, well, I've gotten him, he moved in December 2017. So at that point, I was given, I'm trying to think what it's called from Child Protective Services, but a safety plan, pretty much what he's been with me since.
All right, and you have no plans of changing that family unit in the foreseeable future?
No, however, the father does want his child when he gets out, so I guess that's a battle we have to deal with at that time being.
Okay, but it is not your plan that you resume a marriage relationship or a romantic relationship with him?
No,
And you don't have any immediate plans for such a relationship with anyone else?
I plan to date other people.
Okay.
Yeah, so,
Yeah, and I'm not suggesting you wouldn't. I'm just, you don't have a fiance right now that
No,
you're getting ready
no,
to marry?
no.
So there are no immediate plans to
No.
change that family unit?
no.
Okay. Moral fitness of the parties, clearly he's been convicted of something. What was he convicted of?
I want to say it was drug trafficking. It was something for 10 years.
Do you have any kind of a record yourself?
No. More so why the marriage probably shouldn't happen, but yes.
Are you in good mental and physical health?
Yes.
Any reason to believe that Mr. Allen is not?
Physical health wise,
Physical or mental?
that's one of the reasons why he will probably be released early for the COVID because of high blood pressure and something else they're trying to figure out. So,
Okay. This child, again, is how old?
he's 5.
5. So is he in school this year?
Yep.
How's he doing?
He's doing pretty good. We're seeing a psychiatrist on the side as well and speech therapist, so so far so good.
Okay, I'm supposed to ask a child of sufficient age if he has a reasonable preference. At age 5, they don't. If he did express one, I'm sure it would be to live with you.
Of course.
And not in prison with his father.
No.
Are you willing and able, once Mr. Allen is released, to facilitate and encourage a close relationship between him and the child, provided that can happen safely?
Yes.
Has there ever been any domestic violence in your relationship with Mr. Allen?
No.
All right, and it says any other factor. Clearly, the big factor here is he's incarcerated. I find that all of the best interest factors weigh in favor of awarding sole physical and legal custody to you. Have you and Mr. Allen already divided all of your personal property?
Never had any personal property.
Never had any together?
I'm sorry, together.
Okay. And do you own any real estate?
No.
Does he own any real estate, to your knowledge?
No, not that I know of.
Is there any possibility of the two of you reconciling?
No.
Do you seek any interest in any pension, retirement savings plan, insurance policy, life insurance or otherwise, endowments or annuities that are in his name?
No.
And are you willing to waive any interest? I'm sorry, and you would want him to waive any interest of any of those things that might be in your name? All right, I forgot to ask, are you pregnant today?
No.
And did I already ask you, is there any possibility of you and him reconciling?
Yep, you asked me that.
Okay.
No way.
All right, I'm satisfied based on the proofs there's been a breakdown in the marriage. To the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood your marriage can be preserved. I'm granting you an absolute judgment of divorce. And I am going to, yes,
Can I restore my maiden name?
absolutely. I would have gotten to that because I'm going to fill out the judgment for you.
Okay.
And you don't know his current address?
Yeah, give me 1 second.
Oh, good.
Phone.
Good, we'll make sure that goes right on this form.
It's FCI.
F,
Ashland.
FCI,
Yep, Ashland.
Ashland,
Yep, Federal Correction Institution.
okay?
P.O. Box 6001. Ashland, Kentucky 41105.
And does he have a prisoner number?
Yes, 55167-039.
Okay, now give me a little time here to fill this in. Are you still at 518 Webb Street?
Yes, yes, Your Honor. do have one question, Your Honor.
Go ahead.
With, me having sole physical and legal custody, is he required to have to pay child support?
Yes,
Okay. That's all.
when he's able, obviously he
Right,
can't
that's why I
now.
thought, why the order was in there, he can't claim.
Yeah, what I'll provide that the child support is suspended while incarcerated.
Mm-hmm.
And then as soon as you get word that he gets out, let the friend of the court know and they'll start making him pay.
Okay. Get settled, we can do joint custody, make it a lot easier.
Peter, while I'm thinking about it, would you run maybe a dozen copies of this?
Sure thing. Thousand, sir?
Yeah, just so I've got extras up here.
Oh, there's a blank one.
Yeah, these are the blank forms, right? And you want your last name changed to
Glaspie,
Glaspie?
PIE.
Okay, Ms. Glaspie, you are divorced. Just a second, as soon as Peter comes back out, I'll have him take you downstairs and we'll make sure we get you a true copy of this judgment.
All right, thank you very much.
You're welcome. Any questions for me? Why don't you make a copy for her? He's gonna have to be served at that address that's on the judgment.
Okay.
Thank you, Peter.
Yep.
Okay, that concludes our hearing. Good luck to you, ma'am.